All rise. Oh yay, oh yay, oh yay. The Court of Appeals for the 4th Judicial Appellate District is now open pursuant to call.
You may be seated. Good morning. I am Irene Rios. To my right, I've got Justice Beth Watkins. To my left, I've got Justice Lori Valenzuela, and we welcome you to the 4th Court. At this time, I'm going to call the case and ask for announcements. The court calls cause number 422-00194 Jerry A. Guzzetta versus Brimhall LQ LLC, doing business as La Quinta Hotel. May I hear from the appellant at this time? Okay. Very well. Okay. Very well. So, Mr. Cobb, you will have 20 minutes. Then Mr. Stolmeyer, you will have 20 minutes. And then Mr. Cobb, you'll have 10 minutes for rebuttal.
Thank you.
All right. You may proceed. You're welcome.
Good morning, Justices Watkins, Rios, and Valenzuela. May it please the court. I couldn't in 20 or 30 minutes possibly recount all the facts that support our arguments, much less the rather chaotic 10 years of litigation in the trial court. So I trust the court has already determined what the critical issues in this case are. Critical to Mr. Guzzetta is that the effect of the proposed settlement that's contained in the mediated settlement agreement, I'll refer to it as an MSA, is to destroy his federal claim under the Defense Base Act, which I'll refer to as the DBA claim. There really is no dispute that one destroys the other, and that the settlement was ill-advised, at least for that reason. And it's hard to dispute that Mr. Guzzetta didn't have a very good reason for insisting that his lawyer oppose the settlement. And it is beyond dispute that a lawyer may not force his client into a settlement without violating disciplinary rule 1.02A2. And that's exactly what happened here. There are, in my view, egregious violations of disciplinary rules and self-dealing by Mr. Stolmeyer. Again, I can't chronicle them all here, but suffice to say that when a lawyer sues his own client in the very same case in which he represents him, and then refuses to withdraw and masquerades in front of the courts as Guzzetta's lawyer serving Guzzetta, when in fact he's filing motions and seeking relief adverse to Mr. Guzzetta's direct instructions to oppose the settlement agreement, there is a very serious problem. Before I get into 4 points of argument, I'll tell the court what we hope the relief to be in this case. First, we ask that the court reverse the summary judgment for Brimhall and either render judgment that the settlement need not be consummated until the conclusion of the DBA claim, or alternatively remand to the trial court for further consideration consistent with this court's opinion. 2, we hope that the appellate court will find that the trial court abused its discretion by proceeding on Stolmeyer's fee claims before Guzzetta's defenses and malpractice claims arising out of Mr. Stolmeyer's conduct could possibly have accrued or ripened. And we ask the court to reverse the judgment awarding fees to Stolmeyer and render judgment that he's entitled to no fee, or alternatively remand to the trial court for reconsideration after there's a final unappealable judgment in this case or in the DBA case. And finally, we ask this court to order Mr. Stolmeyer to restore all of the funds he received from the registry of the court until the malpractice litigation against him is concluded, or to remand with instructions to the trial court to do the same.
Therefore, before you get into your first argument, I do have a question about the procedural history, which is incredibly long and detailed in your brief as you described. But I am curious what the record shows about what efforts your client made to resolve the DBA claim, to get the consent that was required.
In the record, I can't off the top of my head point you to the site, but there was, first of all, was a Rule 11 agreement where the parties to the trial court case agreed to set aside the Brimhall summary judgment order and allow Mr. Guzzetta to do just that. And he did attempt to do that. Second of all, in the record is also an order from the administrative judge presiding over the DBA claim that held that ordered, that found that the DBA claim was not yet dead because Mr. Guzzetta and his lawyer had not yet taken any of the money. In other words, the mere entry into the MSA didn't kill it. It would have to be constructive or actual receipt of the funds. And since that time, the administrative judge has taken no action on this case and is awaiting the outcome of this case to determine whether or not there's a DBA claim that survives at all. I hope that answers your question. That's probably about as much as I know about the DBA claim. Mr. Howard Grossman down in Florida has informed me that it's pretty much on hold until we have some decisions here. So 4 points of argument. And the first is this: the order of August 17, granting Brimhall's MSJ was improper, and the subsequent refusal, despite agreement between both Brimhall and Guzzetta that it should be set aside, was error. The second is that the award of contractual contingent fees to Mr. Stallmeyer was improper altogether, but certainly before a final unappealable judgment enforcing the MSA, because he can't have a fee until there's a settlement that's concluded under his contingent fee contract. The third is that releasing any funds prior to an unappealable judgment in the trial court, prior to the time that the final order became unappealable, is improper because it denies Mr. Guzzetta his access to the courts to argue about the propriety of doing so. The fourth is that refusing to grant the motion for new trial that was filed and to allow Guzzetta to defend the fee claim with ripe malpractice claims and defenses was an abuse of discretion. So to the first point, the order of summary judgment was improper and should have been set aside. I think the thing that's the most striking is it's not every day that a movant for summary judgment gets his summary judgment and comes in 3 years later and admits that it was improper and agrees with the non-movant that it should be set aside. But that's what happened here. The summary judgment itself was based upon, there's really two prongs to the basis for the summary judgment. One, it's based on Exhibit T to the motion, which is a lengthy order of sanctions, death penalty sanctions.
Before we get into the details, so the summary judgment was set aside pursuant to the Rule 11 agreement, was it not?
Yes.
And
then
the client was part of that Rule 11 agreement.
Yes.
And agreed to set aside the summary judgment.
Yes.
And now, is it your position that you're complaining about that summary judgment being set aside when your client agreed to it?
No, ma'am. We're complaining about the fact that it was reinstated. And then subsequently, Brimhall and Guzzetta came before the court with motions seeking the same relief to set it aside and agreeing that the intent of the MSA was that it not be enforced until the DBA claim was concluded. And that I'll address that Rule 11 agreement a bit more, but the Rule 11 agreement was essentially something that all parties agreed to. Let's set it aside. Let's give Guzzetta a chance to go settle his DBA claim. And then if that can't happen within a certain period of time, we can reinstate the motion, but everybody will be back in the same position they always were, which is you can come in and ask for reconsideration, et cetera. And that's what has happened.
Okay,
And,
I'm sorry, tell me in the Rule 11 specifically where you're talking about, where the parties are agreeing that they're going to address the DBA first.
Yes, ma'am.
And I'm looking at the Rule 11 agreement.
The clerk's record 2599 is the Rule 11 agreement. And it provides, quote, the parties agree they will not proceed with any pending motions.
What number are you reading from in the Rule 11?
In the Rule 11.
I'm sorry, I don't have it right here in front of me. I just have
Oh,
my
number
excerpts,
7.
so I apologize. The parties agree they won't proceed with pending motions, but specifically reserve the right to re-urge any pending motion or assert any other motion or request for relief deemed necessary in the future. All right, Matt.
Okay.
So the motion for the summary judgment order was based in part on this death penalty sanctions order. There's a few points I'd like to make about that. First, no legally sufficient evidence supports the entry of death penalty sanctions in this case under the Texas Supreme Court's opinions that require intentional disregard. Second, the sanctions order was later set aside by the judge that entered it, but the summary judgment order wasn't.
What part of the sanctions order was the summary judgment based on and granted?
It's not clear in the summary judgment order, but Exhibit T to the motion was the sanctions order. And I would point out the sanctions order expressly forbid Guzzetta to even file answers with affirmative defenses and verified denials. And then at the hearing on the summary judgment, the arguments were made that he doesn't have any defenses, no verified denials. And therefore, he goes to a hearing with both hands tied behind his back by this sanctions order. He could not plead, according to the order, the very defenses he needed to.
So it's your position that because that Guzzetta was precluded, your client was precluded from amending pleadings and responding to the summary judgment. And I know there were objections because he did raise some affirmative defenses and those objections were sustained. So is that what you're telling the court?
In part, yes. I think that's a big problem with the summary judgment order because to the degree that the information that was excluded from the summary judgment record by sustaining the objections, those were necessary for him to defend the motion. As I mentioned, in the sanctions proceeding, the argument was essentially that Mr. Guzzetta had failed to show up for a deposition. There was no evidence of intentional disregard of any of his duties as a litigant. In fact, there were proven medical reasons for his non-appearance at the deposition. That was in the record. And there simply is not anything remotely close to the proof required for a death penalty sanctions order. Mr. Stolmeyer even admitted in the hearing that monetary sanctions would be adequate to address the failure to attend a deposition. Now, I personally don't even think that was warranted, but there it is. So our position is that there was clear abuse of discretion in granting the sanctions order. But the summary judgment order was also based in substance at a minimum on the MSA itself. And Guzzetta filed a reply and asserted that he had no duty to perform the settlement agreement yet because paragraph 4 of the settlement agreement provides that all the liens, potential liens, had to be addressed and that the DBA carrier may very well have a subrogation interest in the money that's now in the registry, the $250,000. And he was dead right on that point. But the summary judgment was granted anyway, August 17th of 17. Then 3 years later, on August 4th of 20, Brimhall and Guzzetta both filed motions to set aside the summary, to reconsider and set aside the summary judgment. Brimhall stipulated in a response to Gazzetta's own motion to set it aside that it should be set aside. In Brimhall's motion, and I quote, they say, accordingly, Brimhall requests the court to set aside the previous order as requested in plaintiff's motion, and that's at CR 2497. In a response filed to Gazzetta's own motion to reconsider, Brimhall stipulates as follows. Defendant Brimhall's acquiescence with plaintiff's sought after relief is based upon its interpretation of paragraph 4 of the mediated settlement agreement that required satisfaction of all legally valid liens out of the settlement proceeds. Subsequent to the signing of the MSA, it has become apparent to defendant Brimhall that the determination of all legally valid liens could not have occurred at the time Mr. Guzzetta was ordered by the court to sign the release. So at this point, by August of 20, Brimhall and Guzzetta are stipulating that the intent of the agreement was that the DBA claim be resolved first, so that the DBA carrier's subrogation interest could be protected. Clearly, they had disagreed on that originally, but now they're like going, gosh, well, this should be set aside. And that way, Mr. Guzzetta can go, deal with his DBA claim. They agreed that the settlement agreement could not be enforced at the time because the conditions to enforcement hadn't occurred, and the intent was that the DBA claim be concluded first. And that raised at minimum a fact issue on intent under the MSA, but it really appears to be conclusive as to the intent when you've got the parties stipulating what they meant. And this was true back on August 17 of 17 as well. The DBA, the MSA said what it said back then.
I have a question for you about the practical implication of your first argument. Let's assume, for argument's sake, that we agree with you, that we reverse the summary judgment as to Brimhall.
Mhm.
We still have the summary judgment, the parallel summary judgment as to Stollmeyer. So how does that get you the relief you're seeking?
Because Stollmeyer didn't have standing to move to enforce the MSA. He's not a party to it. He simply is not a party. He doesn't have the standing to come to the court and either join in Brimhall's motion or file his own. He's
But
not a party.
complaints about standing are typically arguments that have to be raised in the trial court, right? Because if you had raised those arguments, then the trial court would have, and Mr. Stollmeyer would have had an opportunity to cure potentially.
I believe those were raised, the standing argument in Brimhall's, one of Brimhall's replies to Stollmeyer's, and he didn't file his own motion for summary judgment. Let's be clear about that. He simply filed something called intervener has joined in
the order.
Brimhall's motion. And there was setting aside that doesn't comply with 166A, and there was no 21 days notice of any motion for relief by Stollmeyer. You still have the problem that he doesn't have standing. Brimhall raised that in one of their responses. And I believe, I should know the answer to this for right now, but I believe George Spencer raised it in his reply to the summary judgment, or certainly in his motions to reconsider. But I do believe that was raised. But had it not been, standing is a component of jurisdiction. I don't believe the court has jurisdiction to grant the relief for Stollmeyer on enforcing an MSA, which he has no standing to enforce. I just don't believe that can be done. And
It
that
seems like here you're talking about fundamental error. Let's dig into that a
Yes.
little bit. Help me understand, especially in light of the fact that the state bar dismissed at such a preliminary stage, the grievance filed against Mr. Stollmeyer. Help me understand what specific facts here should trigger such a narrow doctrine.
okay. Well, let me get to that page and I'll go right through it. The fundamental error, of course, is, we're relying on Texas Industrial Traffic League and PERTL that are cited in our brief. Courts regularly recognize that in disputes over attorney's fees or claims by attorneys for fees against clients, the disciplinary rules are all but controlling. They form part of the substantive law that addresses a lawyer's entitlement to fees. There's a plethora of case law on this cited in our brief. The seminal case, or the most recent case from the Supreme Court on recovery of attorney's fees, either under a contingent fee or quantum merit, is Hill versus Shamoon and Norman, the Supreme Court in 2016. In that case, when it was before the Supreme Court, the state of Texas filed an amicus brief asserting that the state has an interest in the administration of public justice, and therefore it wanted to be heard on the question of whether the contingent fee was enforceable. And then, of course, there was an alternative quantum merit claim in that case. And then the court went on and gave us the standards for the proof in quantum merit claims. But the point of that is the state recognizes that the public has an interest in the question of the conduct of attorneys and fees. The Corpus Christi court in the Quintero case that I cited in the brief had some compelling language on this too. Holding that it is the duty of the courts to independently address disciplinary violations by attorneys because the disciplinary rules were designed to protect the clients of attorneys and the public in general from the intentional wrongdoings of attorneys. And it noted the importance of protecting all clients by a vigorous and thorough enforcement of the disciplinary rules. And that meets, in my view, the elements required to justify review for fundamental error.
So are you suggesting that every case involving a lawyer's disciplinary review would be subject to fundamental error review, where there wouldn't have to be any error preservation in the trial court?
No,
So how is this case different from other similar cases, from other cases involving the disciplinary rules?
when a law, in the context of fee contracts and fee disputes, illegal contracts should not be enforced by the courts. There are a number of cases from this court and also from multiple other courts that address, for example, prohibited provisions in a fee agreement that are illegal may void the entire agreement. When a lawyer's conduct rises to illegality, that can and should be addressed, and courts should independently refuse to enforce illegal contracts particularly where a client who's not a lawyer, obviously, is unaware of what lawyers are and are not allowed to do with respect to fees.
So what's the illegal, I'm
Go ahead.
sorry. So what's the illegal contract in this case
Well,
specifically?
The illegal, the contract is not necessarily illegal, but the conduct in enforcing the fee was. So what you have is a particularly unusually egregious act of a lawyer being the attorney of record for his client, suing his client in the same case, and then going to the presiding judge, for instance, the order that Judge Knoll granted before the docket call in April of, I think it was 18 or 19, and masquerading as Guzzetta's lawyer and seeking relief to force him to sign the settlement agreement within 5 days, even though he's been fired and instructed to oppose the settlement agreement.
Your time is up, Mr. Cobb.
Thank you.
I mean, if you need to finish, I'm not cutting you off. Did you need to wrap that up or are you done?
I can wrap this up pretty quick if I may. So the release of the funds, I've addressed pretty well. I think it clearly before the judgment is final and unappealable, to release those funds to Mr. Stolmeyer before Guzzetta could go challenge the order enforcing the MSA was a disgrace, frankly. Mr. Guzzetta has the right to come to this court and to challenge that order, particularly in a situation where where even the movement to the summary judgment agrees it should be set aside.
Right.
The final point was this: that the refusal to grant the motion for new trial was an abuse of discretion. We have malpractice claims that can't accrue until there's a legal injury, and that typically is after you have a final and appealable judgment in the underlying case. But here we have the possibility of a legal injury occurring before an unappealable judgment by the release.
I'm going to need to stop you because I
Yes, ma'am.
think you're going into another argument and your
Okay.
time is up.
Thank
Thank you. Yes. You may.
Good morning, Justices. I'm Patrick Stallmeyer, one of the appellees, and I want to have brief 27 issues. So I'm going to try to move as quick as I can by responding to council's situations here. The Rule 11 agreement was to settle, to help Mr. Guzzetta settle successfully his DBA case, because his lawyer in the DBA case, Mr. Grossman, failed to get prior approval of the MSA, even though my client, my former client, talked to him on the telephone during mediation, asking if there's any liens, reported no. And also he had a workers' compensation case in California. The mediator told him to call that person too and asked the same question. He responded, no, but there was a medical lien that was waived. The Rule 11 agreement is a settlement. The consideration for Mr. Guzzetta is that, and these are all terms I came up with. This was not something that someone said, let's go settle the case. I've been trying to settle the case for years, and this is the one that they finally agreed to. The consideration for Mr. Guzzetta is if we set aside the summary judgment, then that opens up his DBA case again, because there's a ruling from the DBA court, a federal judge, who said, if that summary judgment is upheld, you forfeit all your benefits. That's a legal malpractice claim against Mr. Grossman.
Before we get too much more into that, do you agree with appellant's interpretation that the term enters into a settlement agreement with a third person? The federal statutory language is only triggered when there's cash in hand?
Well, it's even,
Or do you
That
think
doesn't-
it's when the MSA was signed
that triggers the DBA case.
that would potentially extinguish the DBA case?
Okay, the question is, if I get paid attorney fees, that would extinguish the case?
My question is, what is the triggering mechanism? The statute, as I understand it, says that recovery is barred if someone enters into a settlement with a third person. Does that mean when the MSA is signed, or does that mean when the check is cashed?
That means all of that. There's several different components that I understand. You have to have a signed MSA or a settlement agreement. You have to have payment going, and this is the third party case. You have to have a settlement third party case. Number one, you have to have a valid MSA. Number two, the money has to be paid to the third party lawyer, such as me, and I have to put it in the court registry. Or money is paid in behalf of Mr. Guzzetta to me, and I put it in the court registry. Then I control that. Once all the money is to me, there's a settlement that is upheld and being valid, and there's some other components also. And there's also a condition on if the client actually signs a release. And that's why he refused to sign the release, because Mr. Grossman told him if you do it, it busts your DBA case. So it's 5 things that trigger that. But what the DBA court is relying on, the number one is the summary judgment. It's got to be valid. And as the court knows and the record shows, Mr. Guzzetta failed to file a compulsory counterclaim, which is mandatory to the intervention filed by Stolmeyer. Stolmeyer requested these attorney's fees in the intervention. And I dispute what Mr. Kolb said. The fact that I file an intervention after I'm terminated without cause is not legal malpractice. It's not breach of fiduciary duty. And the court also knows that at that point in time, if they fail to file that compulsory counterclaim, they're out of court on res judicata and collateral estoppel. And that's the Richter case from this court. Did I answer that, Jan? Thank you. And going back to the Rule 11 agreement, the consideration, like I said, for Mr. Guzzetta, is that he is freed up for the blockade on that summary judgment. My consideration was as soon as he had 30 days to settle that case, my consideration would be, I get to withdraw my attorney fees immediately. But what Mr. Grossman did, who was in charge of this after his lawyer, Mr. Guzzetta's lawyers actually signed this agreed to vacate. They also signed an agreed motion. If they didn't settle it within 30 days, they agreed I could file an uncontested motion to revoke, setting aside that summary judgment. And they also actually signed an agreement that the summary judgment is valid. That's a contract. What happened? 30 days came and went. He didn't settle it. Instead, what he did, he put it on the docket, the litigation docket where it's at now. So of course, I didn't get anything. And here's comes a breach I have to deal with. I waited another, I think, 6 months after the 30 days ran, giving him more time to settle that case, and he still didn't do it. So at that point in time, on June 28th, 2021, I filed that agreed order validating the summary judgment because that was my relief. That's the only relief I had if they breached it. And also of note, Mr. Guzzetta didn't perfect appeal on that June 28th, 2021 order, just like he didn't perfect appeal on the original summary judgment. In fact, Mr. Guzzetta failed to perfect appeal on every single item that happened in the trial court, the exception of the disbursement order and final judgment of January 24th, 2022, where my fees come in. And it's important that the court know is that Brimhall interpled the total $250,000 in the court registry. And that was at the same day that got an order signed for interpleader. That money went into the court registry later. So when the court registry has that, the court knows that is in control of the trial court. And at that point in time, interpleader law is crystal clear. Anyone who wants an interest in that money has to file a claim to it. If they don't have standing. So Mr. Guzzetta has never filed a claim. In fact, he did the opposite. He told the trial court, we're not making a claim for Stollmeyer's fee. We want Stollmeyer to be paid. Mr. Guzzetta praised Stollmeyer after the work he did on the slip and fall case because it was extremely difficult, even more difficult than most of the cases I do on slip and falls. And once that money went in the court registry, Mr. Guzzetta told the state bar in his grievance, it's important to note, was dismissed after a full adjudication. It went through probably around 13 different people. It went through the lawyer. It went through, I think, 2 investigators. Then it went through a summary disposition panel where you have I think you 4 lawyers and maybe 3 public folks. They looked at it, investigated, and they dismissed it, barring him to appeal. So as far as the disciplinary charge was, they just said no just cause. And this court knows just cause is probably the lowest burden he could ever do. That's higher than preponderance of the evidence on some malpractice case, which Stollmeyer never did commit. I have found there was 41 counts of legal malpractice committed by Mr. Guzzetta's lawyers. Now I have a list of that. My time's running down, so I don't want to go through that now, but if the court pleases, I can send those to the court for further consideration in a letter form if the court's interested in that.
And that's what, again, the counts?
The counts that they committed.
That won't be necessary.
Okay,
Thank you.
Judge.
I do have a question for you. Let's talk
Yes.
about your filing of November 14, 2016.
Yes.
And let's talk about the hearing that you set on November 18, 2016. Help me understand, do you first of all dispute that the order that you received was signed before the docket was called that day?
Well, it was Brimhall's order, not mine.
Okay.
Everything that Mr. Guzzetta instructed me to file, I filed to help bail out Grossman, who didn't get permission. Let me just walk back a little
But
bit.
had Mr. Guzzetta terminated your relationship or your services on November 17th, and the hearing was held on November 18th, where you appeared with defense counsel and signed an order, an agreed order?
Mr. Guzzetta sent an email in the middle of the night on the 17th. We had a hearing in front of Judge Alcala. Judge Alcala demanded Mr. Hinojosa produce proof that Mr. Stollmeyer received that notice of termination.
Mr. Hinojosa was not at the hearing with you. He showed up at docket call and the case had already been, the order had already been signed.
Yeah, we had an agreed order. First of all, Mr. Guzzetta asked me to help him get more time to get his case settled. Grossman told him he needed a day. And he needed more time because earlier we had a discussion where I informed Mr. Guzzetta what are the next steps. And Brimhall was going to be moving for a motion to enforce him signing the release, which is ministerial and collateral to the MSA. It doesn't affect its validity.
But if you were simply taking actions to further your client's interests at your client's request, as you suggested, help me understand the decision to do that before the case was called.
Well, before I went to court, Mr. Guzzetta either wrote me or called me and says, let's withdraw the motion and don't enter an
The
order.
motion to enter to order execution of release?
Yes,
Okay.
and that's in the appendix. I've got all my emails going through all the discussions. So that was withdrawn. I had a chance to confer with Brimhall before the hearing. It says, look, all the stuff that he wants to do through me is withdrawn. But of course, Brimhall wants the execution of the signing. Then I convinced Brimhall to give him a few more days because he had a separate order. He had a separate motion and give him a few more days. But the most important thing was, please give him a chance to go back in front of the court if his DBA case isn't settled as represented by Grossman. Because what I know about Grossman, that probably would not happen. And I told Brimhall, if we can have a clause in there that Mr. Guzzetta can have a show cause order as many times as he wants to go in front of the court and show I haven't settled my DBA case, and my lawyer says if I sign the release, it'll bust my DBA case. And I convinced Brimhall to put that in. And what's critical about that is apparently he hired Hinojosa and didn't tell anybody about it. Hinojosa comes into court without talking to Brimhall, without talking to Stolmeyer, and he comes into court with another order that nobody knew about. And even the judge didn't know what was going on. So the judge signed that order. What that order does, it binds him to 60 days to sign that release. That kills his DBA case, because according to Grossman, that kills his DBA case. So what that did is that bound Guzzetta to the death sentence on his DBA case, because he had 60 days to do it. And it was his motion through Hinojosa, so he can't get out of it. He owns it.
So the order that you were a part of that was signed gave him 5 days to sign the release.
5 days plus.
New lawyer comes in and he gets 60 days for Mr. Guzzetta to sign a release.
With no conditions. He cannot go back to the court again. He's frozen to that 60 days. He owns it. And what's important is when the summary judgment was entered, the trial court had an opportunity to look at that. And Brimhall used that in a motion for summary judgment, because the basic issue on the defense of the summary judgment by Guzzetta is I need more time to sign the release. I need reasonable time. And Brimhall just shoved that down his throat and says, look, Judge, the intent is shown by Mr. Guzzetta. I have an order that says 60 days. So what Hinojosa did is just cratered his entire case. And what's important, Judge, we went in front of Judge Knoll, and Judge Knoll sanctioned the pants off of Hinojosa. He said he committed fraud against the court. He committed fraud against Judge Knoll, and he violated disciplinary rules, and he sanctioned awarding me attorney fees. So when I filed my intervention, that was after Hinojosa became his lawyer on the 17th. Then he actually substituted on the 21st. My intervention was filed on the 23rd. So I was able to go into that hearing with Judge Knoll, and because I saw that order, and I said, that kills him. Talking to his lawyers, I said, that's got to go. So I was able to convince Judge Knoll to set that order aside to save Guzzetta. His lawyers didn't do it. His lawyers didn't know how to do it, but I did it. Even though I was an intervenor, I bailed him out at that point in time because I was able to as the intervenor. There was nothing about Stolmeyer trying to force Guzzetta to do anything outside what he said he wanted to do.
You have 5 minutes left.
Another important issue is that on the MSA, Mr. Guzzetta states, and his lawyer states, that's a fair and reasonable settlement. He agreed to the settlement. He was happy with the settlement. And there's emails going in where he sent me that says he praises me for getting that settlement for him. And he wants to see me getting paid. The MSA has no conditions. Contrary to what counsel says, there's not a single condition in that MSA. He represented to the court, there was a condition that he settle his DBA case before the MSA is valid. That's absolutely false. That's the same thing they tried in the trial court, and the trial court said no. The Texas Supreme Court, there is no conditional language. There's only one piece of language in the lien section in that MSA, and it just lists people that might have a lien. And it's stated there might be a lien on the DBA case. And another thing I did to bail him out is CNA, which is the insurance company on that DBA case, filed an intervention trying to argue that they had a legally valid claim. And that's the language in the MSA. That's very important. I saw that, and when I was intervenor for my attorney fees, I saw that, and I told his counsel, that is not a legally valid lien. It's conditional, it's optional, it's possible. So I briefed that, filed a motion to strike, went in front of the trial court and won. So we got that done. That's the second time I bailed him out. The third time was trying to get a settlement. So even though that I was fired without cause, I did everything I could to bail out these 41 malpractice counts that these lawyers did.
I have a question for you about, there's a couple aspects of this case that I'm struggling with.
Yes.
And one of them we've talked about, the events of November 17th and 18th. Another thing that I'm having a hard time wrapping my head around is Brimhall's desire to go forward, even after Guzzetta had non-suited the claims against it. And I understand the posture that you are in here today, but help me understand why in the world did Brimhall go forward? It had a get out of jail free card.
Brimhall was adamant that they wanted that paper release, that their insurance company had to have that paper release. So that's why they filed everything against Mr. Guzzetta.
Mr. Guzzetta filed a non-suit.
I understand that.
And the statute of limitations had expired,
Correct.
right?
Correct. So the non-suit, the case is over.
So the insurance company wanted to pay $250,000 rather than $0?
No, the signing of the release wasn't a condition to the MSA. The MSA stands. They had to pay the $250,000. They couldn't get out of that. But what they wanted was that piece of paper that says that he's released. I talked to them probably 50 times, tell them you don't need it. Here's the law. You've already won your summary judgment.
Force that MSA would have been Mr. Guzzetta, right? If he says, I don't want the 250,000, I don't want to settle because this is going to extinguish my other case that is potentially worth a lot more. So he was saying, I don't want this. I'm non-suiting. So.
Well, what his non-suit was because the MSA called for him to dismiss his case. So he filed the non-suit, which later became a non-suit dismissal with prejudice. But what he didn't file was didn't sign was the release. His own lawyers non-suited the case. And we all understand what the non-suit is. So, but Brimhall said, we still want the piece of paper, even though it's not a condition, it's collateral, you don't need it. In fact, the MSA has that language buried into it that Mr. Guzzetta releases all parties and dismisses the case with prejudice.
While you were representing Mr. Guzzetta, what steps did y'all take that are described in the record to settle to resolve the DBA claim?
What I did, those three things that I did when I wasn't his lawyer.
But my question is,
What Guzzetta did?
while you were his lawyer, what did y'all do to try, because this case has been going on for 12 years now.
about 3 or 4 months after he signed the MSA, Grossman called me. He had possession of the MSA from Guzzetta because I asked Guzzetta to send his lawyers the MSAs. He had it in his possession. He told me on the phone, we had 1 or 2 conversations. He told me on the phone that he did not get permission or prior approval for Guzzetta to sign the MSA, so he's in trouble. And if I could help bail him out. Here's his problem. He asked me to file a motion to set aside the summary judgment and say this. Number one, lie in my motion that the mediator told Mr. Guzzetta that he could sign the MSA and it won't hurt his DBA case. Absolute lie. He said, that doesn't work. Blame Mr. Scott, the DBA or the Brimhall lawyer, say that he told Guzzetta he could go ahead and sign the MSA and that won't hurt his DBA case. And so he asked me, I said, no, I'm not lying in a motion because what you're doing is you're asking me to commit fraud against 2 individuals and you're asking me to commit fraud on the court. But Grossman had another plan. Grossman had another scheme set up to defraud the DBA and the federal government that he tried to pull me in. So he wanted to use that to pull me in to a potential federal crime. And this is what he did.
Mr. Stolmeyer, I'm going to caution you not to accuse other lawyers.
Well, this
If
is,
you could please just refrain from doing
Yes.
that and
I-
speak to the record.
I
within the record.
apologize to that, but I can tell you how I found that out. So Mr. Guzzetta sent me 2 letters. One letter, excuse me?
Are they in our appellate record?
Yes. One letter, and these were in November of 2016. One letter was sent to the DBA lawyer that said, Mr. Guzzetta has not yet settled his DBA case, but there's only an offer of $250,000. So I'd like to settle the case, which hence to help him bail himself out. But the problem was the DBA counsel had the MSA and busted him out on it. That, and another letter came in that Mr. Guzzetta gave me that says, sorry, you breached the DBA law, you did get prior approval, so his case is done under 933G. That's the death penalty. So
Mr.
what
Stolmeyer.
Thank you.
he
You're
was
out of
doing
time.
is, thank you.
Thank you. Mr. Cobb, you have 10 minutes.
Thank you, Justices.
Mhm.
A tremendous amount of that argument was outside the record and couldn't itemize all of it. I'll address several points made by Mr. Stolmeyer. The first is that the orders, I believe it was November 18, 16, were on Brimhall's motion. That motion hadn't been filed on that date. The only motion to enforce on that date was Patrick Stolmeyer's. So the representation that was made there is incorrect. One of the arguments was that it was made to the order that was obtained before the docket call was made to help Mr. Guzzetta. And nothing could be further from the truth. One point that Mr. Stolmeyer made was that subsequently an order was entered giving Mr. Guzzetta 60 days to conclude the DBA claim. And that once he did that, he was frozen. He was shut out. It killed his DBA claim. Well, the order that Mr. Stolmeyer got, given him 5 days, did the same thing. There's no distinction between the two if he's right. So he's acting adversely to his client here. And the second point that I'd like to address is whether or not there should have been a compulsory counterclaim. The claims against Mr. Stolmeyer had not accrued yet. They hadn't ripened yet. It would have been inappropriate to bring them, or if they were brought, they should be abated until they've accrued and ripened. And that's the NRA Texas Collegiate Baseball case, which I think is very closely on point to the situation we have here. So if a claim hadn't accrued, how can it be adjudicated? So that's a point. And along with that, I think the grievance issue is a red herring. I think the grievance, first of all, is not res judicata as to anything in this case. And what the grievance committee does or doesn't do doesn't change the facts of this case. And those are this. the court with its very eyes witnessed Mr. Stolmeyer suing his own client to enforce a settlement agreement the client didn't want to enter into any longer, violating the client's instructions after he was terminated. Whether he got the email in the middle of the night, I don't know but he got it. And yet he didn't withdraw for, I want to say something like 6 or 7 or 8 weeks after that. And he's still suing his client. This is all happening in the presence of the court. Why is that important? If you look at the Royden case, it's a 1960 Supreme Court case. That case holds that a lawyer is entitled to no compensation when he abandons or withdraws from the client before the litigation is concluded or commits a material breach of his agreement. The court is watching all this happen. The court, as a matter of law, has to deal with the problem that he's withdrawn. The case is not concluded, and that's what we're here to decide today. Was it really concluded? Was the MSA enforceable back then or not? If not, then the case wasn't concluded. And the court's witnessed this material breach. As a matter of law, the court can't award the contingent fee at all, or at best, under this court's opinion in Rocha versus Ahmad and some others. He is only entitled to quantum merit, but he never pled quantum merit.
But those cases, they're limited to when counsel was discharged with just cause. And it seems like the trial court here made an implicit finding that he was discharged without just cause, right? By ordering the essentially breach of contract damages. Doesn't that mean the trial court impliedly found that he was discharged without just cause?
Those cases that I cited to you, Royden and Rocha, do not deal with terminated for just cause. Royden is a lawyer was terminated with just cause and committed a material breach. No compensation there. Mandel versus Wright and Thomas, which Mr. Stolmeyer argued to the court when he was asking for his fees, is one where the lawyer's terminated without just cause. And Rocha versus Ahmad is one where the lawyer was terminated with just cause. But we've got more here. We've got an egregious situation where a lawyer is suing his client while still attorney of record for him in the same case in which he's representing him. And this is happening in the presence of the court. And this kind of gets back to Justice Rios, your question about what's illegal, what was done that's illegal. Whether the contract's illegal or not, the conduct in trying to enforce the recovery of a fee is illegal. It is so obviously offensive to the disciplinary rules and the administration of justice that I believe it should fall into a category that deserves fundamental error review. And that will be obviously one of the questions that you'll answer. But I think the record on its face in this case belies and even prohibits the court from awarding a fee that is contrary to the law in the state of Texas. I just don't believe that he can do it. The court can do it. And Mr. Stolmeyer made no effort to prove up a quantum merit. But maybe this is the easiest argument. If the settlement agreement hadn't been concluded and Guzzetta is not entitled to his money yet, Stolmeyer gets his fee agreement requires a recovery, a complete recovery. If the MSA was not enforceable and remains that way at this time because really nothing's changed, why is Stolmeyer getting a contractual fee under his contingent fee contract? It hasn't vested yet. The right to the fee doesn't vest until the money is in the client's hands. That's a very simple way to deal with this issue. If the MSA is not enforceable, he gets no fee. It's just that simple. You can read his contract. That's what it says. So one final point, and then I'll give back any time that's left. I want to talk about the money in the registry of the court and who has an interest in it. Brimhall on September 17, 21, came to the courthouse and argued, this is the day that Mr. Stolmeyer is trying to withdraw his money, get an order to withdraw his money from the registry. Brimhall's lawyer and says, we still have an interest in the money And we don't want to be in a position where the money that we deposit goes to the intervener and then an appeal happens and we have to try and unwind what has happened if the appellate court decides something else about the MSA. Well, that was absolutely right. That's why we're here. That's what happened. Brimhall then tells Judge Gabriel, look at your own order of September 28 of 20, in which the court recites that Brimhall still has an interest in the money, and yet the court lets the money go without adjudicating Brimhall's interest.
Did you have a way to supersede that? Did Guzzetta have a way to supersede that?
I think in this situation, it should, that Mr. Stolmeyer could have been ordered to supersede if he wanted to hang on to the money. I mean, to post bond pending appeal.
But I mean, it happens all the time that there's a judgment, and then to prevent collection efforts on that judgment while the appeal is pending, you just post an appellate supersedious.
Well, by that time, the money has already gone into Stolmeyer's hands and bank account.
That's what I'm saying. At that point. could you have
I think
superseded?
that somebody could have asked the court to require Mr. Stolmeyer to post a bond to keep the funds.
Or wasn't there an order in place? I think there was an order by Judge Arteaga that said that changed a previous order. And so this order by her said that there could be a distribution of funds from the interpled funds, even though it wasn't a final and unappealable. judgment at that
My
point.
recollection of that is that Judge Arteaga's order said no funds leave until there's a final non-appealable judgment, but then Judge Gabriel set it aside.
Okay, I got
Yeah.
that backwards. You're
Yeah,
right. You're right.
and so, but again, to allow the funds to leave without providing some security for Stolmeyer if he had to return the funds was just wrong and prejudicial to Guzzetta.
Mr. Cobb, so earlier you said if the MSA is not enforceable, then Mr. Stolmeyer wasn't, should not have recovered fees.
Right.
Should not have withdrawn the fees. But we had that summary judgment that was reinstated by agreement of the parties, which said it was enforceable. It was binding and enforceable, did it not?
What you're saying is partially true. I mean, to the degree what you just said is partially true, but here's the problem with that argument. The agreement to reinstate the summary judgment is not an agreement to accede to it. The parties retained all their rights to challenge it further and did challenge it further. Both Brimhall and Guzzetta came in later and challenged it further and said, please set it aside. It's wrong. So
And the court ruled on that.
the court
Yeah.
refused to set it aside.
Right. Okay.
Right. So, I mean, there was a summary judgment, right or wrong. Yes, you're correct about that. I mean, but for Mr. Stolmeyer to argue that that was some sort of settlement agreement or that we waived the right to challenge that here or anywhere else is incorrect.
Your time
Thank
is
you.
up. Thank you very much. Your case has been submitted. And as soon as you don't have any time to address the court on argument. Yeah, I'm going to have to deny your request. Thank you, Mr. Stolmeyer. As soon as we have an opinion, you will receive it. Thank you. Yes.
Thank you very much.
All rise.
See you all.